we move now to the next panel, which is actually quite a nice follow-up on this, because it's about effective advocacy in construction arbitration, making your case and persuading the tribunal. And of course, that very much also depends on who the tribunal are, who the members of the tribunal are. So chairing the panel is Riaz Hussein, KC, who is a barrister at Elkins Chambers. He, of course, acts as a leading counsel in litigation, particularly before the appellate courts, on difficult legal and tactical issues, but also he acts as an arbitrator and as counsel in international arbitration, and is ranked as a leading silk for construction, professional negligence, and international arbitration in the main directories. So I would ask the panel then to take their places, and we look forward to hearing how best to make your case to an arbitral tribunal.
Thank you, Renata, for that kind introduction. I'm very curious and excited about the panel we have today, because we have the privilege of 4 formidable arbitrators who are also counsel. And as counsel in arbitration, as an advocate, you're always wondering what is the best way to get through to the tribunal to persuade them and to get their attention. And we're going to get the perspective of 4 very experienced tribunals who've also been counsel. So I'm looking forward to the discussion. Construction advocacy is a quite delicious and specialist form of advocacy. You have so much detail, so much paper to cross-examine on, but that is also part of the challenge. And advocacy in construction arbitration is almost a different skill set to advocacy in construction litigation. You have less time. A matter that would be listed in the TCC for 6 weeks maybe set for 4 or 5 days in an arbitration. You have different rules of document production. You have less formalities on the length of pleadings and witness statements, so on. So it is really a skill set that you gain from experience, and we're going to rely on the experience of the people with me. I have with me Philippa Charles, who have had the pleasure of pairing in front of and obviously tested her patience. She is an arbitrator at 20 Essex and was head of Stewart's international arbitration practice. Philippa is a very experienced advocate who now is an equally experienced arbitrator. We have Anya Farron, who is my colleague at the ICC. She's the chair of the ICC Committee on Arbitration and ADR. She's a partner at Phil Fisher, again, has over 20 years of experience both as counsel and as an arbitrator. We then have Jason Fry, KC, who's a partner at Clifford Chance and the head of their, the global head of their international arbitration practice. He's a Secretary General of the ICC court and was a co-author of the guide to the ICC Secretariat's Guide to ICC Arbitration. And again, Jason is an extremely experienced counsel and arbitrator. And then we have Philip Norman, who's a partner at CMS's Infrastructure, Construction and Energy team, again, with nearly 30 years of experience as both counsel and arbitrator. And Philip, interestingly, was based in the Middle East for a number of years, so we'll have that perspective of how arbitration works in that key region for construction arbitration. So we're just going to use some slides just to kind of have some talking points. And I think, Philip, you very rightly said when we were preparing that one of the first things to look at in deciding what's going to be effective advocacy is understanding the nature of the tribunal and procedure. Do you want to talk a little bit about how you approach that and why that's important?
Yeah, I think that's right. Thanks, Riaz. I, as Riaz have said, act as an advocate in arbitrations. I sit on tribunals, but I also, on occasion, use counsel, particularly from the English bar. And those are decisions that are made with a with a multitude of different factors that impact upon what we do. I suspect the starting point, and obviously, I've been lucky enough to work around the world in different legal traditions, in different cultural traditions, is to understand exactly what we're trying to achieve with an arbitration. We're all, as advocates, great storytellers, raconteurs, spin doctors, champions of, justice and the right for our client. And to an extent, we are often egocentrical and narcissistic. And the point is this: we may think that the way we craft our stories, the way we sequence, the way we tell those stories, the language we use, is the most effective and conducive way to bring the tribunal on side. And I've been involved in too many cases where a very Anglo-centric approach just falls flat. The thumping on tables, the consistent fighting about procedure, the short shrift one gives to witnesses in cross-examination may be very effective before certain tribunals, but hopelessly ineffective before others. And so the point when we were discussing this talk was to say, well, actually, if we are going to be effective as advocates, who do we intend to be effective for? And it's not us. To an extent, it's not really our clients because, we're fighting the good fight for them. It's the tribunal that you're before. And you need to understand what that tribunal is likely to be persuaded by, the type of communication it's likely to be persuaded by, and once you establish that, what tools you can bring to your presentation to achieve essentially a decision in your favor. And there were we spoke earlier on the panel before us, and Caroline took some of my thunder, but the panel before us spoke about the use of different tribunal members. And the question is, if you are, or if you have set up an arbitration in a civil law system, the questions you ask are we going to be inquisitorial at this? Or are we going to have some sort of adversarial approach or a hybrid between the two? What is the tribunal going to be persuaded by? You may find yourself in front of a tribunal, especially if you're English lawyers and accustomed to, very, very well established silks and a judiciary. You may find yourself in front of a tribunal that just doesn't deal with arbitration the same way. I kid you not, I have had a chairman of one of my tribunals in a Middle East country who was holding a procedural hearing while driving his Land Cruiser with phone in one hand, the video on, and it was clear the guy wasn't listening to what was being said. How do you deal with that as counsel? Do you think, well, okay, this tribunal is going to go wrong and we need to think about different ways of persuading or controlling it? Do you control it? In other cases, you see, and especially when we've got particularly American opponents or American counsel opposing you, where during the course of examination or cross-examination, they're thumping the table and saying objection every 2 minutes, the tribunal's looking blankly at them, not really understanding what this whole objection process is about, or intervening in every piece of cross-examination you're doing with, the witness has been asked and they've answered, please move on. And they haven't. It's a different tradition. So the real focus is absolutely on understanding the tribunal, what's going to make that tribunal engage with you. Look, this is a massive, massive topic, but I think I can probably sum it up reasonably shortly by saying we all are creatures of our history. We've all grown up in a legal tradition. We've all grown up in a social tradition, which impacts the way that we respond to social cues. It impacts the way that we understand information. It impacts the way we respond or assume the answers to that information or stimuli to occur. But we must stop that, especially if you're dealing with international entities, with international parties who have different ways of conceiving of issues. As counsel, and I come from the English tradition, I'm very careful when I'm cross-examining, for example, Chinese witnesses, not to expect them to do a yes or no answer, but because of their culture, I know that they're going to give me the whole reasoning before they get to the yes or no. And it's understanding that, it's not getting frustrated, because if I were to get frustrated, I would alienate the tribunal. But this is a huge topic. You know, Caroline and her panel have talked about, you know, who the arbitrators are. There's a different way to communicate to lawyers as there is to technical experts who are sitting on the tribunal. Parties and project were touched on, and language. Just bear with me for 1 minute. Language is really important, because the idioms we use in English language. So we're going to kick this off, and you know, everyone knows what kick off means. It's, you know, the fight that happens at 11 o'clock in the pub on a Friday night may not translate well, and you know, you've got witnesses trying to understand it, or potentially other tribunal members. But that's just a silly little example.
That's really helpful. Just before we move away from that, I think one of the biggest nightmares for counsel is a poker face judge or an arbitrator where you don't know what they want. Jason, in your experience, how forthcoming are tribunals when you sat as a tribunal? How forthcoming are tribunals in saying what they want, or should counsel be asking them, or what is the best, most helpful way to present things to you?
Well, you've obviously got a spectrum of approaches. I think some tribunals will give you a very clear indication of what their expectations are right at the outset of the case, and provide guidance to the parties as the matter goes forward. And sometimes, of course, those expectations and demands of the tribunal don't actually align with your own expectations or the desires and wishes of your clients. And so an interesting question then is, do you roll with that, or do you push back? Generally, I think it's probably best to roll with it to the extent that you reasonably think you can, without compromising the integrity of your case. But then, as you say, other tribunal members, I think, can be very circumspect and don't give very much away. And you need to do a lot of background research and intelligence, I think, on them, what they've written, other cases that they've sat in, to try and find out what sort of people they are and how they're likely to think and to approach certain issues. Are they going to be more intuitive in their approach, more equities-based? Or very factual? Are they somebody who's detail-oriented or not? And then, you know, I think as we've just heard, it's really very important to try and remove yourself from your own default setting, to tailor your advocacy and approach towards those tribunal members. Speaking for myself, I like to give parties a degree of guidance as to what I think would be helpful for me to understand the issues and decide the case. And I will do that generally, I think, in hopefully a fairly balanced and open way, without necessarily throwing a lifeline to one side or the other. But, you know, if they're going through the case and there are issues that I just don't understand, or facts that haven't been properly explained to me, I would prefer to say that, and give an opportunity to the parties to address me on specific sticking points, rather than go away and deliberate in silence afterwards and perhaps make a binary and possibly incorrect decision.
I think both parties always appreciate that. Just moving on from kind of the nature of the tribunal, written advocacy is so important in construction arbitration, because there are so many items in dispute, typically in a final account or in a delay claim. And you're not going to get through them in the oral advocacy. So the written advocacy, both in the pleadings and then the all-important post-hearing briefs, which are, again, a counsel's nightmare after the adrenaline of the case is finished, are very important. So, Philippa, do you want to talk about, in your experience as an arbitrator especially, what is effective written advocacy?
Yeah. Thanks, Riaz. And if you think the post-hearing brief is a nightmare for the advocates, just pity the poor arbitrators who have probably forgotten most of what happened by the time the post-hearing briefs finally show up. I think in terms of effectiveness, I've put a few points together. Structure, as far as I'm concerned, is absolutely critical to the effectiveness of what is almost always going to be a very long document. I am a big fan of lists of issues, even outside of an ICC proceeding. I generally try and get the parties to agree one at the outset and then to come back and revise it before the hearing, so that it's very clear by the time I come to decide what is still an issue between the parties, and that it is expressed in a way that I then use as a means to find my way through the evidence and to ensure that I'm actually answering the right questions for the parties, because ultimately that's what's important to them for the longer term. I have a few sort of do's and don'ts, if you like, as part of this thought process. And I think it comes back to some of what we've said already about culture and what works well with the tribunal. I find rhetorical written advocacy deeply irritating, because it's totally ineffective. You're saying things that you are either not backing up with evidence, or that you're seeking to pull the wool over my eyes by suggesting that the evidence is something other than it actually is. I'm always going to check those cross-references. I'm always going to look for them. And so I find, as I say, I find rhetorical pleading deeply underwhelming. And it usually makes me think that there's less to the case than meets the eye. In terms of length, as I've said, you can't avoid a long pleading very often in a complex technical case with many, many, many issues. But I think in the wider context of presenting the case, I do sometimes feel that, you know, the kitchen sink is put in, again, perhaps for client-facing reasons, but in any event, it has to be well structured if it's going to be effective, because if I'm sitting down to read a 300-page document, I need to understand where I am in it. And therefore, length alone is not necessarily indicative of prospects of success or anything else. So I think it's important for the length to be managed as far as possible. As I say, consider the tribunal's perspective. Ultimately, our role, our job, is to give the parties at the end of it a clear answer and an understanding of why the issues have gone the way they have. That is the job that we are doing. And if you have that in mind when drafting, what you're going to draft is something that says, here's what you need to find and here's why you need to find it that way, as opposed to presenting the minutiae of the back and forth between the parties during the course of the dispute, which are all very interesting, and everyone on the counsel side and indeed on the client side has kind of particular hot button issues, which often come to nothing in the overall scheme of things. So I think that having the idea in the back of your mind of what do you want the tribunal to do with this document will help to structure it most effectively. There's the endless debate about whether you have statements of case or memorials in construction cases as well as in others. And I don't necessarily have a view as to what is better. I think it is very much horses for courses, and most tribunals, I think, are open-minded. But you have to give some thought to what the appropriate structure is in a particular case. If you've got a lot of legal issues that might be threshold issues, it may make much more sense to have a statements of case process rather than a memorials process, at least in the first instance. And then we come to the dreaded post-hearing briefs. And I think, as I say, because they come a long time after the hearing, it's really important that they serve the right purpose, which is not to repeat everything that's been put in the 4,000 pages of pleadings and submissions I've already read, but to draw the threads together and to hand me what you'd like by way of an answer. And I think the most effective post-hearing brief is one that says, now that you have heard these 85 particular things, here is how you can decide the list of issues. And it can be quite short, and it's therefore very, very effective.
Just on two of those points there, the rhetorical, the lack of use of rhetoric and also length. I think oftentimes you'll get one side having the length is because every page they're reminding you how wrong the other party is. And often as counsel, that's more aimed towards a client rather than the arbitrator, and then becomes a cycle because the other party then has to respond to that.
Yeah.
And do you feel that the commercial court, for example, in England is very prescriptive about the length of pleadings? Do you feel that there should be some more prescription in some of the procedural rules about the length of statements of case?
You mean procedural rules of institutions?
Yes.
Well, I think it has to be tailored to the particular dispute. So I think it's often for the parties in the tribunal to make a decision on length of pleadings. I've seen often, and myself as arbitrator, in relation to post-hearing briefs in particular, some sort of an indication from the tribunal as to the length of those, tailoring, asking the parties to respond on specific issues and questions that the tribunal has, and then also introducing a page limit at that stage. But I think including page limits in rules probably would be, well, counterproductive.
Okay, and then we're going to look very briefly at the documents because it's probably the least interesting of the 5 slides. But just one question which I've always had as counsel, and I'm going to put it to Jason and then to Philippa. What makes a persuasive red fern schedule? If you sit in as an arbitrator and you get a red fern schedule, what would you say is the best thing to assist the arbitrator to reach a decision one way or the next?
Brevity. I think, unfortunately, red fern schedules now have become another form of pleading, and you get on every document request an answer to the request and then a reply that can run to several pages, making argument mixed in with points on materiality, relevance, and privilege. And the task of deciding issues on the red fern schedule in and of itself becomes quite a significant job. So I think brevity and focusing in particular on materiality is helpful. And then, of course, issues that may arise in relation to privilege and confidentiality. And the other thing I would raise, and I hesitate to say this because I, as an advocate, probably wouldn't necessarily want to encourage it for reasons of cost, but from a tribunal's point of view, it may actually be helpful to have a hearing on contested document issues to focus the party's attention on what is it that they really, really need in the way of evidence to be brought before the tribunal. Because we all know that it's very relatively rare that the smoking gun is uncovered in document production. And I mean, I had a case recently where we were ordered to disclose 20,000 documents, most of which were subject to a confidentiality process that took 3 months for the tribunal to review. And then out of that pool of documents, 3 documents came into evidence for the hearing and weren't referred to once by the other side. So one wonders what the utility of the whole exercise was.
That's really helpful. What about you, Philippa? Is there any way that counsel can help them with red fern schedules?
Yeah, I think, I mean, particularly if you're dealing with an IBA rules process, the question of materiality is probably the thing by which most of them will stand or fall. And so focusing really exclusively on that, and almost as a respondent to a poorly framed request, simply to say materiality has not been shown, and stop there, because it draws the eye of the tribunal back to what the request actually was, rather than the flim flam around who's right and who's wrong, and what the balance is between the parties. And so I think that does make it effective.
So I think often what we as counsel or drafters do is we go through each limb of the IBA rules, even though it's not really. So you think that saying that cut and paste is maybe not necessary for an experienced arbitrator?
I don't think you necessarily need to have all of the points. If you think that materiality is in the balance, then you might want to go on to the other aspects. But I think if you can stand or fall, a response to a poorly framed request on materiality, then do so, because I think it definitely helps the tribunal.
Excellent. So we're going to move on to 4th of the 5 topics, which is extremely relevant to construction arbitration, and often is a large part of the disbursements that the client or the end user has to encounter in construction arbitration. Expert evidence and examination. Anya, do you want to talk a little bit?
Sure. I think we've already seen from the previous panel that we could be here all afternoon on the subject of expert evidence. I'm just going to focus on sort of one question or one issue for the panel and for the audience. I'm going to say that the role of counsel advocacy, at least, is or should be significantly less reduced when it comes to expert evidence, and interested to hear whether you agree. I say this, I guess, because the most important thing for the expert is to come across, obviously, as independent and credible, and therefore the interference of counsel advocacy, particularly if counsel is egocentric and narcissistic and using a lot of rhetoric, will not be helpful. To that extent. And also, obviously, experts are covering highly technical issues, and there would be most helpful for the tribunal to have those broken down and made clear. And again, counsel, who perhaps only has a superficial understanding of those very technical issues, are not best placed to do that. It's the expert himself or herself to do that for the tribunal. So I've set out some of the kind of issues that are relevant, and obviously with respect to the written report, counsel will have very little role in that, or should have a reduced role in the writing of that. The joint expert meeting and report, counsel's often not present at the joint expert meeting. At the hearing, I think there's an increasing tendency for direct examination to be replaced by a presentation given by the experts themselves. I think tribunals find that extremely helpful. In relation to cross-examination, often experts are helping counsel in the preparation of the cross-examination, and that may be entirely replaced, in fact, by the witness conferencing or hot tubbing. So there, in fact, the role of counsel is replaced actually by the tribunal asking questions. So I think related to that, two concerns that counsel often have is that the reduced control. So counsel loses control of the advocacy. And again, question to the panel and the audience, is that an issue? And also the tribunal has to be much better prepared. So in order to make hot tubbing an effective exercise. And, is it your experience that tribunals are able to take over that role of advocacy where hot tubbing is used over the sort of standard cross-examination?
That's really helpful. And Philip, just if I lean on you, what is your experience of this kind of, well, I wanted to say unorthodox, but it's almost become the orthodoxy now of having the two experts sat together and having some kind of hybrid between hot tubbing and cross-examination. What's your feel about how to be effective in that as an advocate?
Well, as an advocate, it scares me because, all advocates want to control how the message comes out. They want to control the pace. They want to be able to, put their points to the other side's expert so that their expert opinion is to be preferred. It is becoming more common. It does require a lot more engagement and preparation by the tribunal. But what is really interesting that comes out of it from an advocate's perspective is listening to what the tribunal is asking, to see where they're emphasizing, to see which areas of the expertise is being tested. And that helps in advocacy, actually, in terms of how do you then go back and ask further questions of the experts, and potentially how you have to refine the message that you give in closing submissions.
One of the things that surprised me when I started sitting as an arbitrator myself was how important the joint report is to the arbitrator, or certainly is to me. It's kind of it's in front of me. It's my first port of call before delving into the detail of what goes behind the joint report. So I think that's quite an important document. But I think as counsel, you're kind of catching up because that comes quite late in the day. So you then trying to catch up with presenting that as an advocate. I think one of the most helpful things you could do in terms of the expert evidence as an advocate is that in your opening, just make the issues clear to the judge. Say, look, actually, this comes down to 3 or 4 points of difference between them. And I'll be exploring those 3 or 4 points so that what I said, judge, just now. So the tribunal is aware that these are the 3 or 4 things that I need to decide. I think that could be helpful in saving time. I'm sure we're going to hear about experts and some of the questions. So we then come to what everyone kind of traditionally thinks of as advocacy, which is the submissions and the cross-examination and so on. Jason, with your wealth of experience, you want to talk a little bit about best practice and what's persuasive?
Yes, thank you. Well, the remarks I make are probably going to sound a little trite, but it comes back, I think, to where we started with Philip, and that is know and assess your audience before you go to the hearing. How well prepared do you think the arbitral tribunal is to hear the case? And that's quite a crucial question. In the old days, you could walk into the room and you could form that judgment by looking at the number of post-its that were stuck onto volumes of paper or whether the spine of the document had been broken. But now everybody hides behind their iPads. It's a little bit more difficult to form that view. But you'll have a sense of that, I think, from how engaged the tribunal has been throughout the process. Have they been involved actively in the expert process? And from the sorts of questions that they will ask in the lead up to the hearing. And why is that important? Because you're going to tailor your advocacy, I think, to how much you need to sort of lead the tribunal through and inform them on some of the basic issues and dispute, as opposed to focusing on necessarily getting straight into the key issues. So there's an educative process that might be involved. And of course, again, the way in which you present your case is going to depend upon the composition of the tribunal. Are they technical people, as we heard earlier, or are they lawyers? And if they're lawyers, are they civil lawyers or common lawyers? And I want to emphasize that not all civil lawyers are the same and not all common lawyers are the same. I'm often struck by the quite stark differences between lawyers from the United States and lawyers from the United Kingdom, or between Germany and France, for example. So you have to take that into consideration. One of the other things I think that's absolutely crucial is time management. So often advocates get that wrong, and we do it ourselves. You think that you're going to put everything into your opening submissions. You've got an allocated amount of time for that. And an arbitration, of course, you may only have a half day in which to do your opening or your closing statement. And you cram as much information into that as you possibly can, and then find that you're actually running out of time towards the end of those submissions. And there's nothing worse than that, because you lose key points. So my recommendation would be focus on time management, actually do a rehearsal before you get to the hearing to make sure that you can stick to your allocated time and focus really on the key issues, the key legal issues and the key facts the tribunal will need to decide. One other point, which I think is terribly important, and it will depend a little bit on how the case has been pleaded. Do you have memorials? In which case you will have had a lot of legal argument that would already have taken place, or not? Have you had a statement of case, and then will you have a skeleton before your opening statement? Those two different practices will also affect the way in which you present your case at the opening. Now, I put a little point up there on to PPT or not to PPT. Is that a question? Some people have very strong views that you put an enormous PowerPoint presentation of 250 slides in as part of your opening statement, because it's another way of putting your case across. It helps the tribunal. And then others take the view that actually you shouldn't use PowerPoint at all. And it's about engaging with the tribunal and almost having a question and answer session. I fall probably into the latter category. I'm not a great fan of PowerPoint, whether I'm on the receiving end of it or I'm an advocate. But there are different views on that. But there is a tendency these days, I think, heavily to rely on PowerPoint as part of your opening or closing statement. And it can be helpful, I think, if there are diagrams, if there are maps, site maps, etc., to focus attention on particular things. But very complicated PPT presentations, to my mind, are a distraction from what the advocate is trying to tell you. What else do we have on this list here? One other point, which I think is interesting, and I've seen this as a development maybe over the last 2 to 3 years post-COVID, is what I call the hearing after the hearing. And this is the hearing that occurs after the post-hearing briefs. So you've had your hearing, you've then agreed that there won't be an oral closing, you put in your post-hearing briefs, and then the tribunal says, actually, we'd now like to have another hearing to hear you about your post-hearing briefs. And I'd be interested to know whether people think that's a good idea. I've had that as counsel in 2 cases, and I've also done it as an arbitrator at the request of the parties. I thought actually it was quite helpful because by that time the tribunal was really laser focused on a few issues. And usually what happens is that hearing after the hearing becomes a bit more of a question and answer session, and you can get a sense of direction as to where the tribunal is going and hopefully correct perceptions that aren't necessarily in your favor, or exploit weaknesses that have emerged in the other side's case. So maybe I conclude there and we can have a little bit of a discussion. There's lots that can be said about this, but I guess the basic tenets of good advocacy are preparation, preparation, and preparation. At knowing the expectations of your tribunal and managing your time effectively and being realistic about what you can actually achieve for the time that you've got.
Yeah, I think you used a very astute phrase, which I love, which is choosing your battles, because going back to arbitration advocacy being a different skill set to litigation advocacy, is you have very little time. Typically, you'll have 3 hours to cross-examine someone who's written reports of 900 pages. And having that clear idea from the start, well, what are the main issues? Where does the money lie, for example? Where does the time lie? Or what is the point of difference? And really engaging with those issues in that time, rather than asking a few trite questions about every item in dispute. I think that's where I think in the advocacy, choosing your battles is really important.
It's crucial in understanding, I think, as I say, knowing what the expectations are and managing those expectations. I'll give an anecdote of when I was a much younger advocate and I had a hearing and I was about to cross-examine the witness, and it was a reasonably complex matter, and I planned for 2 to 3 hours for this witness, and the tribunal said, right, okay, Mr. Fry, you've got 20 minutes.
Yeah.
And I said, I'm terribly, and this was a German president of the tribunal and a Japanese co-arbitrator and I think French. And I said, look, I'm terribly sorry, but I can't cross-examine this witness in 20 minutes. It's a complex matter. And I gave all my reasons for that. They said, fine, we'll go out and deliberate. They walked out, came back, said, Mr. Fry, you're quite right. We absolutely agree with you. You've got 40 minutes.
Just on that. Sorry, go on.
Sorry, but that's often the case. You know, time is important. So I just want to pick up on the point made about PPTs or no PPTs. Sitting as a tribunal, by the time you get to the opening statements, you will have seen in common law type pleadings the case evolve, in memorial type pleadings, it being fully pleaded however many times. And the concern I have with PPTs is that it's a rehashing, probably often using different words to try and explain the same thing. And it's just more information, you know. So I fall into that latter category where actually the most effective advocacy is engaging. It's talking to the tribunal, it's starting a conversation. It's not the same as court, and it shouldn't be, because ultimately arbitration is about business people coming together to resolve business disputes at its very crudest.
Okay, I had some other questions, but I'm guessing they might be picked up by the audience. We're on 38 minutes now, so Renata, I think we deserve a special.
Very effective
Yeah.
time management.
Any questions, from the audience? Yes, mate.
Was that it? Last one.
Hi, my name is I'm Chinese, but I'm a Spanish qualified lawyer. So my question is really about my home country's arbitration practice. So in China, like many other countries who has been influenced by the Soviet Union of examining expert evidence, they rely heavily on inquisitorial approach, such as court tribunal-led questioning and submitted documentation. And given that China always want to internationalize its arbitration regime and practice, do you think it's a good idea for the common law use the techniques such as cross-examination, hot tubbing, and use of IP rules to be introduced more in China? Because I interviewed some practitioners in China. They told me that the reason why these things are rarely used in China is just because the practitioners are not familiar with this. So do you think for them, in case of China, it's a good idea to approach it more to these rules, or keep up with their old rules? Thank you.
Philippa.
I mean, I think it's always going to be a matter for the parties in each case and the tribunal in each case to work in a way that they are confident will get them to the right answer at the end of the process. And what I would say is, in the context of the sort of hot tubbing type discussion, we've made the point that the burden falls on the tribunal, and in that scenario, the technical expert as member of the tribunal is invaluable, because they will ask the right questions and they will get past the presentational hiding of the dirty laundry, I think, as Jason puts it. And I think, the idea of a joint meeting to narrow the issues between the parties and to keep the scope of what is still disputed is really useful as well, to enable the tribunal then to interrogate what is remaining in dispute between the parties. But I think, the reason these techniques have developed is because they are helpful in the main, and therefore, to explore that in any jurisdiction is probably a sensible move for an international market.
Any other questions? So there's a gentleman at the back, and then.
My question is, there's a growing concern about complexity and time and costs in arbitration. So do you think it would be a good idea for counsel to do away with written arguments and then just rely on oral advocacy and just support it with some presentation to save time and costs? Or would you think it's an effective way to achieve success at the end of the day?
Anya, what's your thoughts?
Well, no, my first thought was no, only because sitting as arbitrator, and obviously when you're faced with having to draft an award, not to have the assistance of written pleadings would make my life significantly harder. But again, it depends. If it's a straightforward case that is of low value, and that's what the parties want, then that may be a solution. But I think in the majority of cases, the answer would be no.
I think, James, you had a point. Renata, we're going to be finished soon.
James Hope from Vinger. Some counsel think that you should repeat things a lot in order to push them home in the minds of the tribunal. And I wondered what you thought about it.
Repetition is not always necessary. If you make clear that it's the key point, you will probably only need to make it once, assuming your tribunal's awake.
Renata, if you just allow me, just one last question to me.
Bad point doesn't get any better the more you repeat it.
Yeah. Exactly.
Since we've got the value of these 4 excellent arbitrators and practitioners here, can I ask each of you, what is the one thing you learned when you started sitting as an arbitrator that you wish you'd known about advocacy as counsel? Philippa.
Oh, God. I think what I would have liked to have done better as counsel would have been to remember that the tribunal is not as deep in the detail as I am when I come to sit. And I think I would probably have been a more helpful advocate had I been more conscious of the fact that the tribunal might have been juggling 25 other matters at the same time as mine, and wouldn't necessarily have first-hand recollection of the letter that I'd sent 6 months previously.
So I suspect that answer might be repeated, but what about you, Annie?
I mean, I'm going to go back to Philippa's point. Tribunals see through rhetoric and gimmicks, so stick to the points and be credible.
Jason?
Well, I don't think I used to do this or do this as counsel, but I do find street fighting among counsel really unattractive and unhelpful.
Not even amusing, entertaining?
No.
No, never.
No, it's
It just distracts from the issues, and the more rhetoric and accusations that go on between the parties in the lead up to the decision on an issue is really rather distracting with one.
It's really valuable, Philip.
Well, I've been in an arbitration where counsel threw a chair at the arbitration because I got
No.
and an English solicitor at that.
Right.
But look, I want to repeat the rhetoric point, because as disappointing, as unfortunate, as surprising as things might be during the course of the inter partes correspondence and the pleadings, it doesn't actually help me understand what the point of issue is. And, as a junior lawyer all those years ago, it feels, I thought that was persuasive, but it's not. It's immaterial.
That's so go ahead. Of course.
Completely out. No. You have to ask the audience whether they accept to have a very short lunch.
You lost control, Renata.
The question is, how much do you believe that the tribunal will decide on the basis of whether they like or dislike the advocate?
They won't, but it will. Likability is important. I'm not going to deny that, but it doesn't alter the fundamentals of who wins and who loses, because those are decisions that you make in an objective way.
No, I think that's ultimately right, but it does impact on how the message is received initially by the tribunal.
Yeah.
I've been in front of Middle Eastern tribunals where an advocate hasn't been as polite or deferential as they might have been, and that's what's in the tribunal's head, rather than the message that counsel is trying to communicate.
I have my own experience. Very recently, actually decided the case where in favor of the party represented by really a very nasty counsel who made my life and Alex very, very difficult. But I mean, at the end of the day, I mean, they were right. So
I think,
as you said, I mean, that shouldn't really have any bearing.
I think likability is less important, but I think tribunal trusting you is extremely important. Not
Trust,
necessarily trusting that you're right, but trusting that you are giving them the full picture. And I think someone mentioned that, Philippa, you mentioned that, getting a lot of rhetoric without any footnotes, you can kind of see through that. I think that can actually taint your good points.
Yeah.
Sometimes.
But there is also an interesting question, sort of related but interesting question about, do you try and win the battle of hearts rather than minds? Sort of quick versus slow thinking. If you get somebody, when I was a very young advocate, said, get the equities on your side and the law will follow you.
Yeah.
And that's a really interesting debate, I think.
Whether there is, there could be a follow-up question whether then you like the party rather than, which is probably part of what Jason said, the battle of hearts or minds. I mean, regardless of the advocates, whether, the position of the party and how the party overall behaved in pre-dispute and during the dispute and things like that. That's, but it's not for now.
Thank you very much. Thank you to all the panelists. I thought it was a very valuable discussion.
Thank you. Thank you.